Good afternoon, everyone, and thank you for joining the 2025 Fair Housing Webinar, Seniors and Second Chances. My name is Jose M. Evans, and it's a privilege to serve as the Executive Director of the Indiana Civil Rights Commission, a role I officially began in March 2025. As you may know, April is National Fair Housing Month, commemorating the anniversary of the Federal Fair Housing Act of 1968. This historic legislation prohibited illegal discrimination in the sale, rental, and financing of housing based on race, religion, color, and national origin. In 1974, sex was added as a protected class to the Federal Fair Housing Act, and in 1988, it was expanded to include protections for disabilities and familial status, further eradicating illegal discrimination in housing. April is also recognized as Second Chance Month, a nationwide observance that highlights resources available for individuals with criminal records, including support for housing and community reintegration. I would like to thank our panelists for their participation. Tracy Richardson, Director of Alternative Dispute Resolution and Compliance here at ICRC. Emily McAndrews, Director of Security and Accessibility for CICOA Aging and In-Home Services. And Rebecca Witter, Reentry Monitor for the Indiana Department of Corrections. We are fortunate to have their expertise to guide today's conversation. And with that, I'll hand it over to Paris Walton, who will be our host and moderator for today's webinar. Thank you again for joining.
Thank you, Mr. Evans, for those opening remarks. Good afternoon, everyone. My name is Paris Walton, and I serve as the Public Outreach and Education Manager for the Indiana Civil Rights Commission, also known by its acronym ICRC. I am excited to moderate today's webinar. Before we begin, I would like to cover a few housekeeping notes to ensure everything runs smoothly. The webinar is being recorded, and the recording will be made available on our website, www.in.gov/ICRC/ and on our YouTube channel in the near future at IN Civil Rights. To access captions, click on the More button in the toolbar, select Settings, and navigate to the Accessibility section to turn on captions. Instructions will also be posted in the chat. If the issue persists, our external affairs team is available in the chat to assist. This webinar has been approved for 1.5 continuing legal education CLE credits. To earn your CLE credits, complete the random polls that will appear during the session. Afterward, you can report your attendance at portals.courts.in.gov. The course number for today is 369847. Again, the course number for today is 369847. If you are interested in receiving a certificate of completion, please fill out the following form by scanning the QR code or following the link in the chat. If you have any questions during the presentation, feel free to ask in the Q&A section, which can be found in the toolbar. Simply click on the Q&A icon to submit your questions. We have reserved time at the end to address the audience's questions. Lastly, please ensure microphones remain muted during the webinar. Now, to kick things off, I am going to provide a brief overview of the Indiana Civil Rights Commission. First, a few disclaimers. ICRC doesn't make the laws, it enforces them. This is not legal advice. For legal advice, please contact a private attorney. This presentation provides general information and guidelines. It is not to be considered official ICRC policy, and ICRC is a neutral fact-finding agency. Did you know that Indiana has consistently set the standard for equal access and opportunity for more than 2 centuries? The legacy began in 1816 when Indiana's first constitution declared the rights to life, liberty, property, and the pursuit of happiness for every individual. In 1885, these foundational principles were codified into law with a public accommodations statute that guaranteed equal access to inns, restaurants, theaters, public transportation, and other communal spaces. By 1945, Indiana addressed employment discrimination with the enactment of the Fair Employment and Labor Act. And in 1949, the state passed the Indiana School Desegregation Law, prohibiting discrimination in public schools based on race and creed. 1961, the Fair Employment Practices Act established a commission to investigate discriminatory practices. However, it lacked enforcement powers until 1963, when it was renamed the Indiana Civil Rights Commission and given authority over employment, education, and public accommodations. Now, fun fact. In 1965, Indiana became a trailblazer by amending its civil rights law to prohibit racial discrimination in housing 3 years ahead of the Federal Fair Housing Act of 1968. The Indiana Civil Rights Law was further amended in 1971 to outlaw sex discrimination, and in 1974, enforcement powers were extended to credit transactions. Another fun fact, the following year in 1975, the agency's enforcement powers also extended to address disability discrimination. Another groundbreaking move by Indiana made 15 years before the American Disabilities Act was passed. Indiana's dedications continued with the Indiana Fair Housing Act in 1991 and the Hoosiers with Disability Act in 1992, aligning state protections with federal law. In 2013, protections were refined to include limited circumstances for veterans. The Indiana Civil Rights Commission practices the 3 E's: enforcing the Indiana Civil Rights Law, educating the public on illegal discrimination, and ensuring equal opportunity for all Hoosiers and state visitors. So now, what is illegal discrimination? It is the unfair treatment of people based on their perceived or actual membership in a protected class. There are 3 forms of illegal discrimination: disparate treatment, when someone treats people in a protected class differently than others not in that class; disparate impact, when someone has a facially neutral rule, policy, or practice that results in different outcomes for protected classes; harassment. Harassment in housing is defined as coercion, intimidation, threatening, or interfering with individual's rights. Tracy will provide examples of each form of illegal discrimination later in today's webinar. So earlier, we defined illegal discrimination as the unfair treatment of people based on their perceived or actual membership in a protected class. So what are the protected classes? Disability, race, sex, retaliation. Retaliation refers to if a community member files a complaint of legal discrimination, the respondent should not retaliate. And if the respondent does decide to retaliate, you can update your complaint with that information. National origin, ancestry, age. This is for individuals over the age of 40 in the area of employment. Religion, familial status, color, veteran status in the area of employment, and then active military status in the area of public accommodations. Through the Indiana Civil Rights Law and the Indiana Fair Housing Law, the Indiana Civil Rights Commission has the authority to pursue the law in the areas of employment, housing, real estate, public accommodation, education, and credit. Now, how can you file a complaint? There are multiple ways to file a complaint of illegal discrimination. A community member can call into ICRC's office, send ICRC an email, walk into ICRC's office located in downtown Indianapolis, file in person at ICRC's Community Outreach and Resource Education CORE program. Now, shameless plug, ICRC will kick off this year's CORE program at Pike Small Claims Court on Tuesday, May 6th from 8:30 a.m. to 4:30 a.m. and at Work One Terre Haute on Thursday, May 29th from 8 a.m. to 4:30 p.m. Lastly, community members can file a complaint online. Now, ICRC's online complaint portal also translates into over 100 languages. And then you also want to make sure that there is a nexus or a connection between the protected class and the act of illegal discrimination. So, for example, I was denied housing, the act of illegal discrimination, based on my familial status, which is your protected class. I was denied reasonable accommodation, the act, due to my disability, the protected class. And you must make sure that your complaint is signed. A complaint cannot be formalized until the complainant signs and sends their signature back to ICRC. There are also statute of limitations. If your complaint is within housing, you have 1 year from the alleged complaint, from the alleged act rather, to file your complaints. And if it is in real estate, or if it is in education, employment, public accommodations, or credit, you have 180 days from the alleged act of discrimination to file your complaint. So now let's talk about the process a little bit. So we already kind of talked about the intake interview. So complaints of illegal discrimination begin with an interview with intake specialists who draft inquiry complaints. If prima facie is met, the nexus that we discussed earlier, the signed complaint becomes formal and assigned to investigators in the employment or repace, real estate, education, public accommodation, and credit teams. Complaints often involve dual filing with federal agencies like Equal Employment Opportunity Commission, EEOC, and the United States Department of Housing and Urban Development, HUD. Once formalized, investigators assess validity, assign docket numbers, and notify both parties. Mediation or alternative dispute resolution can occur anytime, offering solutions like monetary relief or policy updates. If unresolved, the case proceeds to litigation. The legal division handles settlement, discovery, motions, and may represent the public before an administrative law judge or state court. Fair housing cases can elect court unilaterally, while others require agreement. Investigators are neutral and focus on gathering facts to support the case. So just some quick look at the data that ICRC has received. Between 2020 and 2024, ICRC has experienced a rise in illegal discrimination complaints, largely linked to COVID-19 pandemic and the return to in-person work. To stay in touch with ICRC, call us, visit our website, our office located in downtown Indianapolis, or follow us on social media. So, are you all ready to get started? Pop quiz. So, if you look in the chat, you will be able to find a poll. There we go. So I will give you all about 30 seconds to maybe 1 minute to complete the poll. And remember that this is a part of the CLE credit if you want that. And then if you're just a community member that wants to test your knowledge, go for it. So I will give you all, let's see here, about 30 more seconds. All right. Now, it is my pleasure to introduce Tracy Richardson, our first panelist of the day. Tracy serves as the Director of Alternative Dispute Resolution and Compliance here at ICRC. Tracy has a bachelor's in communications from St. Augustine's University in Raleigh, North Carolina, and earned her JD from IU McKinney School of Law. Tracy has served in various capacities as a state employee and most notably worked for a total of 8 years for the Office of the Indiana Attorney General, and has been with the Indiana Civil Rights Commission for 5.5 years, where she began as an advisory attorney. Today, Tracy will provide fair housing overview, along with brief guidelines related to housing for older adults, and individuals with criminal records. Tracy, the floor is yours.
Okay, I have my screen on. I am going to attempt to share. I want to first ask, am I sharing my screen?
Yes, ma'am.
Okay, actually, and I'm going to redo that because I want to share from my PowerPoint as opposed to my computer. And so I'll ask again, am I sharing my screen?
Yes, ma'am. Looks good.
Okay, perfect. So I'm going to go ahead and get started then. Again, I want to thank you, Paris, for that introduction. She's correct. I'm Tracy Richardson. I have approximately a total of 14 years in various capacities as an attorney with the state of Indiana. As she says, I am with ADR and compliance. What ADR and compliance does is basically provide mediation services as well as compliance services for cases that have gone through the commission, either through investigation or litigation, as well as for cases that have reached settlement. What I plan on doing today is providing a very broad overview of the Fair Housing Act, a broad overview and a brief discussion of its intersection with today's topic of seniors and second chances. Just as Paris did, I want to provide the standard disclaimer. This is not legal, but it is informational advice, and the commission does not guarantee it's the most updated or the official policy of the Indiana Civil Rights Commission. If you do need legal advice regarding civil rights or the Fair Housing Act, please seek the services of an attorney. So I will move on again. The format of my discussion will begin with a brief discussion of the purpose behind the Fair Housing Act, who's covered under the Indiana Fair Housing Act. We're going to talk a bit, and also who's exempt from the Indiana Fair Housing Act. There are some exemptions. We're going to talk very briefly about the protected classes, the types of discrimination, and we'll talk briefly a bit of the intersectionality and how that works with both issues of seniors and issues of second chance individuals. Initially, the purpose behind the Indiana Fair Housing Act. The Indiana Civil Rights Commission is a fair housing assistance program agency. We work through HUD. We work with HUD, I apologize, through a work share agreement. We do administer and enforce Indiana's fair housing law, and our laws and guidelines have been intentionally written to mirror federal laws and guidelines. If you look in our statute, it specifically provides that the purposes of the article are to provide for fair housing practices in Indiana, to create a procedure for investigating and settling complaints of discriminatory housing practices, and to provide rights and remedies that are substantially equivalent to those that are granted under federal law. So initially, who is subject to fair housing laws? The individuals that are subject are the individuals that you may normally think of. That includes property owners, landlords, management companies, leasing agents, real estate agents, brokers, realtors, but also homeowners associations, builders, mortgage providers, homeowner financial assistance programs. It could be state and local governments for zoning and land use issues. Anyone could be covered under the Indiana Fair Housing Act unless you have an exemption. Homeowners and tenants can be covered on issues of harassment. So what are the exemptions? We do have specific exemptions that are listed in the Indiana Fair Housing Act. Those exemptions include single-family homeowners, and that is where there's the sale or rental of a single-family home only if the owner was not the most recent resident of that home that is the subject of that sale or rental, if they do not own more than 3 single-family homes at any one time, or own any interest in more than 3 single-family homes, and the house is sold or rented without the use of brokerage services, real estate services, licensed agents. Additionally, that exemption will only apply once in a 24-month period. And if discriminatory statements are used in that sale, the exemption is no longer there, or rental. Also, there's the Mrs. Murphy exemption, which it's known as, and that is basically an owner-occupied dwelling with 4 or fewer families. And the key is owner occupied. So one of those units has to be dwelled with the owner and the additional 3 families to complete the 4-family in order for them to fall under the exemption. There is also a religious exemption. And what that means is that a religious organization can, in limited circumstances, limit the sale, the rental, or the occupancy of a property to a person of that same religion without violating the FHA if it's not done for commercial purposes, unless, again, that religion is restricting by race, color, or national origin. The private clubs have that same type of exemption. Again, you cannot limit by race, color, or national origin. And of course, discriminatory statements will take you out of that exemption. Finally, there are HOPA exemptions, which we'll just briefly touch on, and that exemption really is limited to familial status discrimination. The remainder of the FHA does stay intact. And of course, again, discriminatory statements can't be utilized. What I do want to discuss just very briefly when talking about exemptions is that the Indiana Civil Rights Commission just recently prevailed in an Indiana Court of Appeals opinion in January. That was the case of Fike Investments versus Gregory Wilson in his executive capacity. What the case boiled down to with respect to exemptions was there was a respondent that appealed the commission's findings of liability and damages against them based on a discrimination case. They argued they were exempt from the Fair Housing Act because their LLC owned and operated the property that was the subject of the complaint. The appellate court found that the appellant's behavior and not their statements controlled. And because the appellants were personally named on the lease as the landlords as opposed to the LLC, and they apparently exhibited other behaviors that made it appear as if it was more their rental as opposed to the LLC's. The appellate court found the commission's determination that the exemption did not apply was supported by substantial evidence. And so the appellants were not found to be entitled to that exemption. So if you do want to fall under the exemption, you must specifically follow those guidelines. Next, I'm just going to briefly talk about protected classes because Paris basically touched on them. Under the Fair Housing Act, they do include race, color, religion, which is a sincere and meaningful belief system. It's not necessarily the organized religions that most people are familiar with. Sex discrimination. What the Fair Housing Act does is add familial status discrimination. And what familial status discrimination is an individual that may be pregnant, domiciled as a parent or a legal guardian, or domiciled with written permission of the parent or legal guardian, or in the process of gaining custody of any individual younger than the age of 18. Additionally, other protected classes under the Fair Housing Act are disability, which is an individual with a physical or mental impairment, substantially limiting major life activities. That could include walking, working, thinking, breathing. Many housing providers believe asthma simply is never a disability. It can be, so that is something to consider, and national origin. Moving on, who can file? the Indiana Fair Housing Act defines an aggrieved person as anyone who claims they've been harmed under the act. That can include not only the individual, but an organization that they've gone to who is assisting them to file. Testers can be aggrieved persons under the Fair Housing Act, a protected tester, not the control tester. And again, an organization that utilized testers can be found to be aggrieved for having to go over and above their budget to now deal with a discriminatory activity. The ICRC director can file a complaint. It's called a director-initiated complaint, and that can be gleaned from testing or information regarding a violation to the Fair Housing Act. Individuals in the commission also have, under the Fair Housing Act, the authority to file a civil action known as a temporary restraining order, which is prompt judicial action on behalf of individuals who believe their rights under the Indiana Fair Housing Act are about to be infringed upon by a discriminatory housing act. And an example of that could be someone who is being evicted because they are being sexually harassed by a landlord. So the commission can come in and assist with that process. Basically, the courts have found that the ability to pursue a fair housing complaint is broad. So moving forward, I'm not going to go deeply into the legal theories of discrimination because Paris did touch on them. Disparate treatment, disparate impact. We do find that justice-involved individuals do have a tendency to maybe be impacted on their protected classes due to criminal record policies. So we'll go into that a bit more later on in the presentation, but those are the theories of discrimination and harassment as was addressed. So when can violations of fair housing occur? It can occur before, during, or after homeownership or tenancy. I'm going to talk briefly about types of violations. There are refusals to negotiate, sell, or rent, and that's when an individual simply won't follow up with you, won't have discussions based on your protected class, and it's clear. They may speak to you on a phone call and give you false information, not provide any information, tell you that there's housing that is not available at this time, tell you to come back in 2 months. Steering is a violation of the Fair Housing Act. That's where a housing provider says, well, I think you'd be more comfortable in this particular neighborhood, or there are more people like you in this particular neighborhood. I don't know if you can afford being here. I don't know if you'd enjoy being here. Steering could also be moving someone of a family and saying, I think you need to be on the first floor, and we don't have that available. And since we don't, that first floor apartment may not be for you. You have children under 2. That can be steering. Block busting is a type of violation, and that's where you induce individuals to sell or purchase in a neighborhood because people of a specific protected class are either going to be moving in or not moving in. So that block busting is also a violation. And finally, discriminatory statements and advertising in the sale or rental of a property. The courts have found it to be an ordinary listener standard. And that is when your ads or a statement that you make or your notices kind of give an indication that there's a preference for a specific type of individuals. Something we commonly deal with are student housing, when the housing is not owned by the university. If your housing is not owned by the university, it shouldn't be called student housing because that could be a familial status discrimination. It could discourage someone with children from attempting to rent. Other residential real estate transactions before sale or tenancy that can be discriminatory or discrimination in making loans or providing financial assistance. sentence, again, based on protected classes. Another ICRC case, Raheem Safi versus Stratford Apartments. The aggrieved person alleged that the respondent failed to engage with their housing application based on their national origin. They stated that they were approved electronically through housing, and when they came to fill in paperwork, physically came into the office, all of a sudden they were told they needed to be waitlisted. What happened with the case was the parties engaged in a conciliation conference, and the housing provider agreed to provide the aggrieved person a monetary settlement amount for emotional distress and compensatory damages, and agreed to provide public interest relief. Additionally, other types of discrimination during tenancy, terms and privileges, coercion, intimidation, harassment that Paris discussed. I'll briefly go over another harassment and terms and condition case, Joy Patterson versus Stone Ridge. The individuals alleged discriminatory terms and conditions as well as interference, intimidation, and coercion with their rights based on their protected class. They allege management failed to respond to a number of repair requests over the course of a year, but did not have those times or failures to respond with other individuals of different protected classes. And they also failed to act when they reported they were being harassed. A conciliation conference again was held where the respondents agreed to monetary relief and to engage in public interest relief, such as training. Other types of violations include failures to provide reasonable modifications, and that's unlawfully allowing an individual with a disability to modify their premises, such as adding grab bars to their showers, getting a shower that they can utilize, that type of thing. Or failure to provide a reasonable accommodation, which is an unlawful refusal to make a reasonable accommodation to their rules or policies or practices. The only standard for denial in those cases is if there is an undue hardship. And common types of failures to provide accommodation or common accommodation requests generally are for service animals or assistance animals in housing, where a no pets policy would keep an individual from being allowed to have that. So again, where an undue hardship is not found, a housing provider should engage in the interactive process. Someone that does not or fails to upfront engage in the interactive process could already be found to be engaging in discrimination and should timely manage those requests. Other violations, not meeting design and construction requirements, and I won't go into those. Ending tenancy and homeownership, there are eviction issues, refusal to renew if it's done based on an individual's protected class, or discriminatory services and appraisals, brokering. That's failing to work with individuals based on their protected class in an attempt to sell a home. And again, terminating someone's lease due to their protected class or harassment, as we talked about, sexual harassment for those types of reasons. Those again are violations of the Indiana Fair Housing Act. So what are some solutions? Know your rights. Know that you have a right to file. It's not just governed by your fair housing provider. Complaints at ICRC are neutrally investigated, and so are conciliation and mediation services. Other solutions, our agency does testing, and as Paris talked about, we provide education. And I just briefly want to talk about the fact that ICRC does have jurisdiction over housing for older persons. designed to assist the elderly under federal or state programs, 62 and olders and 55 and olders that have to meet certain guidelines. But again, those exemptions apply to familial status discrimination. So if you do feel like you're being discriminated against, unlawful discrimination in those places could be, again, allowing to do a reasonable modification or have a reasonable accommodation to policies, maybe making an applicant prove they can live independently, not allowing a caretaker. Again, you do, and we do have jurisdiction over those activities. You can file a complaint with the commission, reach out to HUD or a FIP for assistance. With criminal background policies, I just want to provide information again that they can find themselves subject to disparate impact because of policies that blanketly may harm individuals based on protected classes. And so it is important that housing providers ensure that their policies consider the nature and severity of an individual's conviction, the amount of time that has passed since the conviction, and each individual should be assessed on a case-by-case basis, as opposed to applying blanket policies to them to avoid discrimination. And I know I'm over time, so I'm going to stop right there, and I believe questions and answers may come at the end of the presentation. So just want to say thank you for your time and listening.
All right, great job, Tracy. Now, you all, another pop quiz. So if you are having issues with the poll, you can answer the questions in the chat, and then I will also make sure to send out additional communication after the panel or the webinar. So that way, if you weren't able to get the link for the CLE credit or even for the certificate of attendance, you'll be able to receive that information once the webinar is complete. So I will give you all about 1 minute to fill out to take the poll, and then we will continue with today's webinar. About 30 seconds left. So to go over the question is, which of the following is not a protected class within ICRC jurisdiction? Disability, age, race, financial status, religion, familial status, or sex? I see we have some answers rolling in. And just for good measure, I will repeat the question just in case. Which of the following is not a protected class within ICRC's jurisdiction? Disability, age, race, financial status, religion, familial status, sex. And again, I will make sure to follow up after the webinar with all of this information for you all. So continuing on, our second panelist of the day is Emily McAndrews. Emily is the Director of Safety and Accessibility at CICOA Aging and In-Home Service Solutions. In this role, she supports older adults and individuals of all ages with disabilities in Central Indiana by leading a team that coordinates essential home modifications and repairs. Her work ensures that community members have access to safe, accessible spaces where they can confidently age in peace. A proud graduate of Indiana University, Emily brings a plethora of experience from her previous roles in community mental health, transitional housing, and case management. Her comprehensive background allows her to approach home safety and accessibility with a unique blend of empathy, expertise, and strategic vision. Emily resides in Indianapolis with her 2 children, a dog, and a few ducks, rounding out her busy yet fulfilling life. Today, Emily will discuss housing challenges and resources for older adults. Emily, take it away.
Good afternoon. Thank you for that, Paris. That was a really nice introduction. I appreciate that. Are you sharing my PowerPoint?
Yes, ma'am. I'm pulling it up
Okay,
for you right now. All right. Can everybody see it? Or there we go.
I don't see it yet.
Okay. Technology, yay. All right.
Well, you're doing better than I would have. So thank you for taking this on.
Sorry, everybody. Da, 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 da. Okay, try that again. Okay. Okay, are you able to see my screen? Did I click through?
Yes.
Okay.
I
all
think
right,
we can make it work.
Okay.
All right.
I will.
So I am with CICOA, Aging and In-Home Solutions, which is the area agency on aging for Central Indiana. So we serve Marion County and the surrounding donut counties. For those of you who aren't familiar, if you want to go to the next slide, we'll hit the mission statement first. So CICOA empowers older adults and those of any age with a disability and their caregivers by providing the innovative answers, services, and support they need to achieve the greatest possible independence, dignity, and quality of life. So CICOA's role in ensuring availability of safe housing for seniors is to provide resources that help repair and adapt the living space of seniors and those of any age with a disability, so they are able to remain in their own communities for as long as possible. With the current housing crisis leading to housing options that are unaffordable and limited space in nursing facilities and assisted living communities, it has become increasingly important to look at ways to help individuals safely remain in their existing homes as long as they are able to do so. And we can go to the next slide. The Safe at Home department at CICOA has worked hard to secure resources and services that help us work with seniors in our service area to achieve that goal. And I'm looking forward to discussing some of those services with you all today, so you're aware and can share as you're able. So the three main ways that we work to help with safety and accessibility in housing is through modifying existing spaces with adaptive equipment, assisting with the coordination of modifications for safety and accessibility, and assisting with needed repairs that prevent seniors from remaining in their homes, and also assisting with adapting environments which can potentially prevent eviction. Then we'll go to the next slide. So for modifying existing spaces, the most common referrals to the Safe at Home department at CICOA are requests to modify a home to prevent falls or after a fall has occurred. We often coordinate with rehab facilities who are working to discharge an individual to their home, but have concerns that the home will not be as accessible for them when they return. We work with caregivers who are struggling to assist their loved ones with bathing and household tasks due to the limited space in the home. We have recently, about 7 months ago, added the expertise of an occupational therapist to our team of certified aging in place specialists to complete comprehensive home assessments with individuals and create a scope of work that not only includes major modifications, but small changes they can make, such as removing or taping down rugs, increasing lighting in certain areas of their home, reducing clutter. All of those can help prevent further falls and injuries. We are able to work with seniors who own or rent, as long as we have the permission of the property owner to complete what is being requested. And I know Tracy touched on reasonable accommodations in her presentation. We have been able to lean into support from the Fair Housing Center of Indiana to help educate landlords on ADA guidelines, what constitutes a reasonable modification, and support seniors and those of any age with a disability that we're serving's right to accessible housing. Then we can go on to the next slide. I'm sharing these pictures with permission. This is a client story about the impact of a modification. These two pictures are the same bathroom. A client was referred to our department from a rehab facility following a hip fracture. Upon visiting the home, the discharge planning team found that the state of her current home could not accommodate her needs, and modifications and some pretty significant repairs were needed to ensure that she was able to safely return home. When I visited the home with our occupational therapist, it was one of the coldest days of the year, the couple of below freezing days that we had. They had no working heat in the home and no running water in the bathroom. With use of grant funding and coordination with our contractor network and community partners, like Citizens Energy Group, Home Repairs for Good, incredible resources in the community. With help from both of them and our OT, we were able to restore heat and water. The OT created a scope of work that ultimately created a safe space for her to return home with her husband. And following that, our OT continues to offer support and education to make sure that clients know how to use these modified spaces. The grab bar, we can install as many grab bars and modified devices as we want, but if the person doesn't know how to use them, then they're not benefiting them. So as you can see here, the floor needed a lot of repairs. It was creating a trip hazard, and we were able to put in a low threshold shower. She's got grab bars all around in the shower area, a flip down bench, and you can't really see it because of the curtain, but there's a handheld shower wand behind there. So she's able to bathe more independently, or her husband is more able to easily help her if he needs to. So just a really good example. That's one of our more extreme projects probably, but definitely a good example of many community supports and resources coming together to help someone stay in the community, which is the whole goal of CICOA as a whole. We can go to the next slide. So these are our commonly requested modifications. Just for a quick overview, this is by no means an extensive list. We do primarily bathroom modifications and ramps. Those are big ones. Adaptive equipment, if somebody is unable to use their current doorknobs or cabinet handles because they're difficult to grip, we can change those out. Doorway widenings, stair lifts to help them access parts of their home that maybe they weren't able to access before. And one of the frequently missed modifications is kitchen modifications, which I feel is pretty cool and pretty important. If you're working with somebody, or if cooking is really important to you, we're able to lower countertops and help get that area of the home accessible to someone who wants to stay in their existing space. And then, of course, the catch-all other items that are identified as a barrier to safety. So that could be lighting, railings, anything that somebody identifies as a risk to them of a fall or something that's preventing them from being able to stay where they are. All right, so we can go to the next slide. Home repairs. So the availability of funding for home repairs is a newer component to my department at CICOA, and one that we have really struggled to find resources to complete previously, especially in the more rural parts of our service area. There are wonderful organizations that I mentioned earlier that primarily serve Marion County, and with some recently awarded grants from Humana and HUD, we've been able to work with these organizations to start expanding the reach of repair services, which can be crucial for somebody's ability to maintain their current housing. And we've had a lot of instances where somebody calls requesting a grab bar, and we go visit that person and their floor is buckling or they have a roof leak, and putting a grab bar in a home that is dangerous to them otherwise, I feel like we are creating a disservice to that person. So to be able to allocate some funding toward being able to complete the actual repair has been huge for serving our clients. We've been able to recently start accommodating requests for damaged flooring, furnace and water heater repairs, patching leaking roofs, repairing and replacing crumbling steps and walkways. Those can be huge fall risks. And oftentimes we'll get calls from clients who have heard from the city that they need to fix these things. They're a safety violation, but they don't have the means to do that. So we're able to step in and help with some of those repairs and make sure they're linked with the resources that they need. Currently, we're only able to accommodate minor repairs, but the impact has been huge in combination with modifications for safety and accessibility. And we can go to the next slide. So another new addition to our department, we've been adding a lot of things that trying to fill holes in services that we have noticed since this department started doing modifications in 2020. So we are working with seniors and those of any age with a disability with adapting their environment, which can ultimately help with maintaining housing and could even help prevent eviction. We just completed our pilot hoarding and heavy cleanup project for one of our clients. We worked with one of our community providers for a senior who was at risk of losing her home due to heavily soiled and cluttered areas with multiple pest concerns. As a case manager working in transitional housing, this was something that came up very often, and we had very limited resources to help people in that situation. The agency that completed the clean also employs a psychologist that was able to work with the senior during the process to ensure that they were comfortable and felt supported, which is a very important piece to that. The pilot was ultimately a success, and we're looking forward to expanding this program and providing this much needed resource to the community. We also have funding that can be used to add things like visible house numbers for seniors who have multiple healthcare visits, or to allow EMS to find them quickly if needed, outdoor safety lighting, and help with things like replacing smoke detectors, things that, just little items that make a big difference in people's homes. CICOA also hosts an annual event with community volunteers in rotating areas of Indianapolis to provide these services, along with small home modifications and a yard cleanup, to expand awareness of these programs and to encourage community members to participate in caring for and connecting with members of their own community. I think that is a really important piece to involve someone's own community in their care and helping them feel supported to stay where they are. And it's September 20th this year, so we'd love to have you. Can go to the next slide. So this, I like to throw out, especially when I am looking for grants to continue these programs, to further highlight the importance of maintaining programs that modify and repair existing spaces. The cost of assisted living and nursing home placement is huge compared to the average cost of a modification and repair project. So the average cost of assisted living for 1 year, probably on the low end, is $36,000, nursing home, $96,000 for a year of support. The average cost of a modification, which varies, we have some that are $500, we have some that are $17,000. It depends on what their needs are. It's very person-centered, what we're putting together. But if you take an average of $13,000, if someone stays in their own community for 1 additional year, it saves $23,000 to $80,000 per person and benefits the sustainability of their existing housing in the community. The impact these services have is huge, and we are constantly working to expand funding and contractor capacity, contractor network. If you know any contractors, give them my number, to complete these projects as quickly as possible. We can go to the next slide. So how are these services funded? Medicaid waiver services. My department is kind of split in two. We have a part of my team works on Medicaid funded projects, and the other half works on grant funded and some federally funded projects. So with Medicaid waiver services, home modifications are offered with a lifetime cap of $20,000 through home and community-based waiver services. Many individuals in the community are eligible and are not aware that these programs exist. I think sometimes people hear they have to be eligible for Medicaid and think, I don't meet the income guidelines for Medicaid. But if services are needed and a waiver is approved, those income guidelines change. They're higher for people to allow these services to be accessed by people in the community. We also use funding from public and privately funded grants, federal funding through the Older Americans Act, and we recently got a grant award from HUD and an award from Humana to help expand our programs into the underserved rural parts of our service area. A lot of these other services outside of Medicaid waiver are meant to target individuals who are not eligible for Medicaid, even with the altered income guidelines. There are some people that are in the middle that they may not be eligible, but they still are not able to access the resources that they need for modifications and repairs. Okay, we can go to the next slide. So if you know someone who needs help or resources in this area, the best route is our ADRC, the Resource Center at CICOA. I put the phone number here. They do answer all calls live, but they get a large volume of calls at the same time. So the hold time can be a little substantial. I know they're working on that. But my direct contact info is here too. I am happy to answer any questions, or if you have a something that I didn't address here that you think is a hole in services and want to talk it through, I am here for that too. So feel free to reach out anytime. And we can go to the next one. That's just basic CICOA socials. So CICOA has a lot of services outside of what I talked about today, and feel free to look through that and interact with us. So thank you for giving me the time to share what we do today. I appreciate it.
Thank you so much. All right, everyone. We are almost ready for our last panelist of the day. I'm just going to quickly share my screen so that way you all can see her. There we go. All right. Thank you, Emily, for that insightful information. Next, we will hear from our last panelist of the day, Gina Morrow. Gina began her tenure with the Indiana Department of Correction, also known as IDOC, in 2017 as the Program Director in the Fiscal Division. She later transitioned to the role of Training Director for the Community Corrections Division and currently serves as a Reentry Monitor in the Reentry Division. In this role, Gina is responsible for providing resources to facility case management and pre-release staff, conducting new caseworker training, and acting as the division liaison for the provision, review, and accountability of incarcerated individuals' vital records. Gina is also a 2018 graduate and a 2019 team leader of the IDOC Leadership Academy. Before joining IDOC, Gina spent 19 years as a supervisor with Marion County Community Corrections and served as a Marion County Special Deputy. She holds a Bachelor of Science in Education, English, and a Master of Public Affairs in Policy Analysis and Public Management, both from Indiana University. Today, Jenna will discuss housing challenges and resources for individuals with criminal records. Jenna, the floor is yours.
Thank you so much, Paris. So first off, I want to thank you all for allowing us to present and be represented. The Indiana Department of Correction, a lot of people just simply think of us as a place where they lock them up. So I'm going to, I don't know, Paris, I mean, I can share my screen. Okay, let me get to present. I love, there we go.
Perfect.
Everyone
Looks
can
good.
see that. Okay. So some of the things I want to talk about, like I said, was that Department of Correction, or DOC, I'll say DOC because it'll be too long to keep saying Indiana Department of Correction. We're simply more than just locking up people, holding them, and then releasing them. And in the past probably 5 years, we've really made a focus on that personalized case management, cognitive behavior interventions, and setting our individuals up for success when they're released. So with that being said, we do offer a lot of different things in placement. All of our placement begins at 180 days from the time the individual is going to be released, their earliest possible release date, or EPRD. In addition to placement, just to give a side note, side information, we make sure that they have their birth certificate, their social security card, identification. We have BMV, Bureau of Motor Vehicles, come into the facilities to provide those twice a year at every facility, and we have 17 in the state, so that's a lot of visits. And we try to pride ourselves on having those documents for our individuals, because when they get released, they need all those things when they try to get housing, among other things, medical needs, all that. So we help them with that. We have a division that just focuses on employment. We have a transitional health division that helps those that are transition out. By statute, we are required to have everyone signed up for Medicaid, which our transitional health department does before they get out, and then also try to create that continuum of care. So we have a lot of different divisions all coming together and working hand in hand to try to help our individuals when they're released be as prepared as possible. But probably one of the biggest challenges that we face is placement. And I know even in the community, people without some of the obstacles that our individuals face, finding stable, permanent housing can be a challenge overall, and much more so with our individuals. And so what is placement to us? Placement, our primary goal, like I said, is permanent, stable housing. That's somewhere where they're not sleeping on the floor, somewhere they're not just at a shelter or sleeping on the street. We obviously don't want that. And DOC is not allowed to just release somebody to the street. So placement becomes a very big issue. So that's what that is. We have some statutes that require us to provide housing, not just statutes, but we provide housing for some of those that absolutely have nowhere to go. We're just not releasing to the street. We either transport them to their place of residence, we'll ensure that they have a ride that is picking them up, but we never just open the gate and let somebody walk out. So when you see that in the movies and people are just walking out and they're getting on a bus to go somewhere, we don't do that. Either somebody's picking them up or we're actually physically transporting them. So what is the placement roles? Like I just said, we have our caseworkers who have the most knowledge about that incarcerated individual, or II, when entering the placement. So they're required to exhaust all avenues. So they're not only speaking with the II, they are looking at their visitation list. They're looking at people who put money on their books or their commissary. They're looking at past placements to see if those are viable. So we have a pre-release template that we provide to our caseworkers to start working on that placement. And we officially start that at 180 days. But as you know, some of our individuals have burnt bridges, or whether that's with a family relative, whether that's with a transitional placement. So sometimes we even have to start at the year mark of trying to rebuild those bridges. So somebody can start off with the permanent housing. We have found that placement can be one of the number one issues of somebody either returning to criminal activity and then getting back into the system, unfortunately. But also with the role, we also have what we have called as a re-entry coordinator. So that is somebody that is specifically involved, that becomes involved at that 180-day mark. And they provide something which is called a start class. And that is a class that encompasses several categories of things that they're going to experience when they get released. We talk about placement, we talk about medical, we talk about financial, education, employment, all those things. And we even talk about things that I know CICOA was talking about for aging. We have an aging population that's going to be released that the internet wasn't even around. Cell phones weren't around. Everything's electronic now or online. So that can be very overwhelming to some of our aging individuals that get released either, or even applying for applications for housing. Most of it is online. And it used to be you just called up, you made your $15 application fee. There was a minimal check and you could get accepted. And placement has become much more of a complex process that a lot of our individuals being released, whether they're aged, which happens quite a bit, or even younger folks that maybe have never had to apply for housing. So we get that realm, and we've really tried to focus on some of our aging population as well, because they've been, as we call it, down so long that they almost want to stay. We've had some people asking if they can stay to their maximum date because they are so fearful, or they don't have any of that support system now. They either have moved on, passed, or, a variety of reasons. So we have a reentry coordinator that works in tandem with our caseworkers and our transitional health and our parole to try to find as stable as possible a placement. And they also ensure that they have their vital records before they're released. And then that also includes our transitional health, which I mentioned before about the Medicaid. They deal with assisted living as well, nursing home placement, which again can be a very difficult and complex process, and overall that continuum of care. They're also the ones that try to, and they may work with CICOA in some things about getting some of those adaptations to housing if they're going back to home and now they need, ramp access, or they may need bars, arm bars to get in and out. I just recently had a family member that we had to retrofit quite a few things with arm bars just because they had that balance issue. So those are little things that we don't think of that can be huge things for a lot of our folks, especially that have medical issues, to get some of those, what we call some of those like wheelchair walkers, hand bars, grab bars, those types of things. So our transitional health meets once a month, and we make sure that and everybody else, every other division has somebody on that meeting as well. So we're all talking about what does that person need? It's coming up. What do they need when they're released? And then we have our parole division. Now, not only do they monitor people that have been released and have a portion to be community supervised, but they assist us in that placement aspect. So once we get a placement, we send that information to our parole, and our parole goes out specifically and checks and make sure, one, it's a viable option, two, that the sponsor or homeowner or whoever that might be is acknowledged and willing to allow them to live there, and if they meet the certain aspects and some legal restrictions. So that's what we try to do when we're trying to find placement. We always try to look for 2 placements, even if we have to do a shelter placement. We're still looking to that day of release where we might be able to find something more stable or provide them resources after shelter placement runs out. But it can be very challenging. This is our number one, I think, challenge. Okay, not wanting to, oh, there we go. And then we get to the why of placement. We have those special needs placements that have traditionally been a medical or a mental health code that are now fall under what we call special needs. And we start working on those as well as the 180. And probably the most challenging aspect of our placement are sex offender population, or those that had a high media presence when they were arrested or incarcerated. And we also consider special needs or high profile people that have been incarcerated 10 or more years. So with sex offenders, most of you may or may not know, there are legal restrictions to where they can reside. And it can become a very, very small field of choices that they have. So one, they can't be within, a mile or 100 yards or a mile of a daycare, a registered daycare, not just somebody who has some children in the home, but daycare, parks, schools, sometimes a library if there's children's classes that go on there. That also includes any children in the house. They can't live somewhere where there's children in the house. Now, the court may have adjusted an order that might say if their own child is there, it depends on the situation. But also, we find a lot of placement or losing my words today. Apartments, buildings, and housing, especially even nursing care. We have a lot of sex offenders that need nursing care that will not accept somebody just purely on the basis that they're a sex offender. So this webinar is really good to kind of recognize that and see what avenues they may have, so they're not discriminated against, but restricted based solely on that offense. And then we have those high media profile cases that some providers, some placement providers, housing providers just don't simply want to deal with because there's high media presence. They don't want to deal with that headache. So a lot of times they put that in their policies or they might find something that limits them from renting out to them. And then the other spectrum of a really high profile, somebody that's been incarcerated 10 years or more. Like I said, there's so many things that are electronic that even 10 years in, they might not understand the process, get overwhelmed with the process and say, forget it, I'm not doing that. I'll just go sleep on somebody's couch or on their floor, and they couch surf, and that's not very stable, and that doesn't promote their success upon release or with any other requirements they might have, whether it's probation or parole or community supervision. So we really try to make sure that they're aware and understanding. And it could be, we're starting to have, most of our individuals have tablets. They're like little mini iPads, but they're tablets. We've also been developing some computer lab options, which is a whole nother set of things that they could go on and either practice filling out applications or forms, how to explain certain things or certain gaps. A lot of times if you have rented in a long time, a lot of rental places would be like, there's not a rental history. So that's kind of a red flag for them. And then if they explain why, depending on how they explain it, that conviction might be a red flag for them, for that renter. So those are the things that we really, really try to work on. Again, if somebody's coming up for parole board release, that's placement is a requirement before an II can be released. So unfortunately, they might be eligible, they might be ready to be released, but if they don't have that placement in a stable placement, they can't go to a shelter, then their parole can be denied, unfortunately. So with that being said, if a sex offender or somebody that comes up on their maximum release date, we can't hold them any longer. We do have a couple systems in place. So before I get to that, there was something I wanted to mention. For our placements, I did mention a little bit, we always require 2 addresses, regardless of type of supervision, when they get released. And we always, if they are moving out of state, they say, hey, my aunt lives in Illinois, she's going to accept me. They still have to put down an Indiana residence or an Indiana place to stay, because that transfer to Illinois might take 3 weeks. It might take 3 months, and it might get denied. Illinois might say, no, I don't want that guy with a robbery conviction coming to our state. They don't have to take them. So that also, where the person has viable, stable, permanent housing. However, if that person is still on paper, as they call it, parole or probation, that state might not accept them, or it might take some time. So they always think, well, I get released, I'm going to Illinois. And that's not the case. It can be sometimes. We try to start that process also. We can start that process at 120 days out. There is a fee for that, though, for the paperwork. But we could start that process 120 days with that hope that it is accepted and they can directly go to Illinois. So that's one of the things that we kind of look at. So we have something called, we have self-pay versus a DOC assist versus a parole assist. So while somebody is incarcerated, they are able to work. It's not a high-paying job, but depending on how long they've been in, and if they're saving their money, they could have some money, or people put money on their books, whatever is in their bank account. If we can determine that they have at least a week's worth that they could say at a hotel, then they can self-pay and we can release them to that hotel. And we have a lot of relationships with different hotels in the state that do provide a reduced price for some of our folks being released. So they can decide to be a self-pay. Like I said, we just don't let anybody walk out of the door. They have to have somewhere they're going. But then we also have something called a DOC assist. A DOC assist is only for sex offenders that are being released to parole. And yes, it's kind of narrow, but it's because it comes out of our budget. So if they're on probation, unfortunately, we can't assist them with that. We do work with probation and try to find placement or see if they have any kind of assistance. But when it comes to a sex offender, we exhaust all efforts of placement. And we document that we've tried. We look at every possible thing. We bring it back in and say, is there anywhere that you can go? And we submit a DOC assist for them, even if they refuse. And what that is we pay our parole division, our SOM division, which is for the sex offenders management, will pay for up to a week, and depending on the circumstances beyond that, for them to stay at a hotel while they're still working on trying to find more permanent housing. Depending on the circumstances, we can't extend that, but we have a finite budget that we work with just for that. So, and it may not be approved until it's very close to their release date, because we're going to work up to the point that they get released. Without having them, it's not ideal for them to go to a hotel, but we're not going to release them just to the street. And then our parole division will continue to work with them and their resources on the outside to try to find them more stable housing. And then that's different from a parole assist. So this can include everyone but sex offenders who are going on parole. So we have a whole different pot of money and budget for just sex offenders with DOC assist. And then we have the parole assist. They have to return to the last county of their residence or commitment. Because if they wanted to go live somewhere else, that would mean they'd have stable housing somewhere else. Otherwise, we look at that last county. And we can use that parole assist if there's no shelter available in that county. And there are some counties in Indiana that do not have shelter capabilities, that do not have shelters. And it could be a parole recommendation that they use that. And it's the same concept where they would get put up for a certain amount of time in a hotel until parole can continue to work with them to find somewhere for them to live, or maybe if they have to transfer to another county, they can assist them with that. So with DOC Assist, it is simply just for sex offenders, kind of same concept. We continue to work with them, and Parole Assist as well. We can send individuals to shelters. There are a lot of restrictions with different shelters, and there's also time restraints. So we usually really try to continue to work with them through our parole, or if they're on probation, through community corrections, to try to find them that permanent housing. And vital records plays a big part because you need to have an ID. You need to have social security number, all those things to get placement, rent housing, rent an apartment. So that has been a big push for us in getting that. And we apply for that. And one thing I didn't mention, all vital records, whether it's a birth certificate, an out-of-state birth certificate, it is at no charge to our individuals. We pay for, the DOC pays for that. The only thing we cannot do is if somebody was born in another country, unless it was on a U.S. military or it was on a U.S. site, whether it's a consulate, a military base, then we can assist them with that. But we don't have the capabilities of getting them out of country birth certificates. But out of state we do, which we also pay for those. And then finally, another barrier, and I'll probably mention this again, a challenge to us finding placement is a bill that passed, I think it was last year, HEA 1087, which requires us to, if we are transporting, here's the difference. If a family member or somebody who's been approved is picking that person up, they can go live in any county in Indiana where they have that permanent housing. If we, the DOC, is transporting that person per HEA 1087, we have to transport them back to the county of which they were convicted in. Now, that can provide some additional barriers because if they have nowhere to go in that county, maybe they were in that county, they lived in the next county over, but they got convicted out of that county and there's no shelter there, they don't have any permanent housing. That's where it can get a little complicated. And we've been seeing some of our parole assists happening there because they don't have that until they can then, once they get out, then request parole to switch counties. So that's been a little bit of a barrier. So those are some of the whys we're doing. And then the who and when do we notify? So we have different dates and they're very set, kind of gives all of our staff in the different divisions kind of a checklist timeline of what happens when in that process of getting somebody out and finding them placement. So we go through our transitional health. Most of this all starts at the 180-day mark. And some of those are when? Immediately at 180 days, immediately when all placement options have been exhausted. We really try to not have a last minute placement. We want to get that placement done as soon as possible. However, if we get that placement at 180 days, we are still checking up to the time they leave that it's still a viable option. And we not only check with that individual, but we also check with the placement that they're going to be living at, that it is still viable. Some of the roadblocks we run into as well are, I think this is roadblocks we run into is some placements don't accept, like if you have to apply for them, don't accept it 6 months out. And I see why. They're not going to hold a bed for us, transitional locations. So sometimes we have to apply at that 30, that 14 to 30 day mark. And that's a little nerve wracking for us because then what if they don't have a bed? What if they're denied? So those are some of those things that we've been looking at. We've really been trying to work with outside partners and community divisions to try to get the word out that our individuals are coming back out into the community regardless. And wouldn't you rather have known that we've provided them stable housing where they're less likely to recidivate, than have them just somewhere laying their head anywhere and being very unstable and falling back into some of their old habits or some of their old decision making. So the more we work with the community and try to find those stable placements, or working with apartment buildings or complexes or owners, and our sex offender division, our SOM division, has been making some partnerships, not necessarily any contracts or anything, but some good partnerships with some building owners that will rent out to our sex offenders. That's primarily in the Indianapolis area because there's more opportunity. And where we run into more and more problems or challenges are in our southern counties. And so and some of our northern, but a lot in the south because there's not a lot of industry down there per se, as far as a little bit more rural, less shelters, less transitional housing that is available for our population. So what I would say, if you are someone that knows of placement options, or you've heard of a transitional or of an apartment, we certainly vet those and vet those programs, because we want to make sure that the program is a viable program. They understand some of the requirements that our individuals might have, but we're always looking at making partnerships and collaborations and trying to find more and more options for our individuals to have placement. And so that they're more successful. That's one less thing. If you're worried about where you're going to lay your head that night, you're less likely to be worrying about whether, a lot of other things. So placement is certainly a huge identifier. I'm constantly looking for grants and things like that to help supplement and support and subsidize initially somebody getting out so they don't have to worry about it. So that's it's kind of what we do. And that's one of the things I was really happy to be invited to present today, because I don't think a lot of times we know all the things that we're doing at DOC, and we're constantly looking at improving, adding on efficiencies and what works and availability. So there's a whole menu of things that will make our population successful when they're released. So again, my name is Jenna Morrow. I'm one of the program director, reentry monitors, and that's in our reentry division. So we have we have 17 adult facilities. We have some juvenile facilities. So we are constantly busy trying to help our case management staff, our reentry coordinators, our transitional health, getting those good placements. You can reach out to me. My email address is listed there, and my phone number. Email is probably the easiest and fastest way to get a hold of me. And we are also on in.gov/IDOC, and there's a lot of those different divisions if you want to look into a little bit more about what those are all about, and reach out to them. That'd be great. It gives you a little better understanding of what we're doing, what DOC is doing as a whole, not just supervision, but also the rehabilitative efforts that we're trying to do to make our population successful and not come back. We don't want to see people come back. So with that, I will turn it back over to Paris, and I thank you for your attention.
All right, thank you so much, panelists. I know that we are currently at time, but we are now going to jump into our question and answer session. If you have any questions or comments, please feel free to use the Q&A section, which you can find in the toolbar. Simply click on the Q&A icon to submit your questions. So I'm going to set my timer in true teacher fashion to 1 minute, just to give everybody time to submit their questions. And if we do not have time to answer your questions today, I will be sure once again to follow up with all of this included in the information later on after the presentation. So 1 minute starts right now. So once again, if you have any questions, you can put them in the Q&A section, or if it's easier for you, you can go ahead and put them into the chat as well. About 30 seconds left. And you can always ask questions afterwards as well. The panelist information will be on the next screen, and you can also submit questions to me as well. So Emily, it looks like this question may be for you. Is CICOA available in Madison County?
Yes, actually, we did just expand into Madison County. So we can help in Madison, Delaware, and Tipton now.
Perfect. Any other questions? Our 1 minute timer has gone off. Karen, you can either put your question in the chat or in that Q&A section. It's at the very top of the toolbar, and it's just a Q&A icon. I'm just trying to make sure everyone had a moment to get their questions in. Okay. All right. Well, if you would like to get in touch with any of our panelists, their contact information is on the screen. We encourage you all to connect and share resources about fair housing. As a reminder, this webinar has been approved for 1.5 CLE credits. To earn your CLE credit, you can report your attendance at portals.courts.in.gov. The course number for today is 369847. Again, the course number for today is 369847. If you are interested in receiving a certificate of completion, please fill out the following form by scanning the QR code or following the link in the chat. And once again, this information will be sent to you all as well. And finally, we would like to hear from the audience about today's webinar. You can access the survey by scanning the QR code on the screen, or again, following the link in the chat. Please take a couple of minutes to complete the survey and let us know your thoughts. This panel has been engaging and informative. Thank you so much for attending today, and enjoy the rest of your afternoon. Goodbye. All right, I'm officially ending it, you all. Thank you so much.